It's good morning to everybody. That I'm sure that you are hearing me. That what I put it on the screen, can anybody will read it so that I could know that you are hearing me. I'm hearing you. Yes.
Good morning, sir.
Very morning. Read.
Intel Intellectual growth should start at birth and cease only at death. Albert Einstein, Professor Dr. Muhammad Sahib Hussain.
Yes, that is the thing which I want to convey to you. It gives you the sense that you are reading. And today class that I already posted that today I would like to do the presumptions. Yes, the presumptions. What are the presumptions? Why do we need the presumption? Do you have any idea?
Presumption is same as that of assumption, no, sir?
Yeah, but in the assumptions, it is a ordinary terms, and the presumption is a legal terminology. So the presumptions are there. Suppose if a person will be not known for the 7 years more, 7 years or more, the presumption is
He may death.
he may be no
Death
more in
may
this
occur.
world.
Yes, sir.
So that is the presumptions. So in certain cases, presumption will be taken into consideration, and it is to, I don't say exactly to avoid the, yes, it may say that avoid the time factor also. So let us see the what are the presumptions are there. So the statutes don't affect the monarch, king or crown or state. That means we will see that what it will not disturb. We cannot put behind the bar the president, but we can put the behind the bar the prime minister, because a governor also, so long they will hold the office. So there is one presumption. Statutes don't operate retrospectively. Yes, whatever the statute should be there, especially the criminal statute, it should be only prospective effect but not retrospective effect. So existing rights are not to be inferred with. So whatever the existing right will be there, it will not be interfered with a repealing act. So let us see that how it can be made. Statutes don't change the common law. So statute, the common law principle generally will not be there, because common law is such a law. When there is a statute law is silent, at the time common law will fill the gap. Suppose if you bury the common law will rule you from the grave. So that is the power of the common law. So next, mens rea is required for the criminal liability. So whenever the criminal liability would be there, generally we will say the mens rea. That the guilty mind is there or not. So it will be observed over there for the criminal liability. If a statute deprives a person of his property, say by nationalization, he is to be compensated for its value. Suppose that your land will be taken by the government, at that instance, that the government has to give some compensation to you in lieu of the land which is taken for the public purposes. A statute is not intended to deprive a person of his liberty. So whenever a person wants to be arrested, the due process should be there, that should be followed. A statute generally has effect only in the country enacted. Suppose a statute is there, IPC is there, Indian Penal Code is there, it cannot be applicable in the other country. It is only the territorial limits that the statute will be there. And a statute generally has effect only in the country enacted. Yes, that is what I said just now. A judicial decisions where the presumptions are followed are rebutted. So in the judicial decisions, sometimes the presumptions will be rebutted and presumption will be followed. So let us see throw the light on one after another, because generally the presumption they may ask in the short questions. Suppose if they ask in the long question, then you have to write in detail. So let us see that how much I can cover in this class, because the time is now 11:40. That means 10 minutes are over, because you joined a bit late, but doesn't matter. Late is better than never. So states are now number one. Statute don't affect the monarch, that is the king or crown. Now the state, because now the king is not there and crown is not there because of democracy, we will say state. And here states are protected by the doctrine of sovereign immunity from having to pay the damages in most cases. There is a immunity would be there for the state. For instance, if the police does the lathi charge, at that instance to control the mob, unruly mob into the rule, to control it, at that instance you cannot bring an action against the police officer, because the police officer having the immunity, because he wants to control the unruly mob. At that instance, he may use the force, even lathi charge, and the last resort, they will fire also. First they in the air, later on the nozzle will be down from the legs to the upper side. So there are also the problems recovering the damages from the individual government officials. So the immunity will be given for the governors, presidents, ambassadors. For example, a prosecutor who knowingly present false testimony that wrongly convicts an innocent defendant may not be sued for damages. So public prosecutors and judges, they are given certain immunities. This protection is given to them. They can exercise their best judgment without fear and lawful suits. In some cases, however, this leaves injured citizens with no legal recourse. So these officials may be subject to the criminal prosecution cases of the truly alleged conduct, illegal conduct, but this happens quite rarely and does not help the injured person. So certain immunity will be given over there for the officials, those who are rendering their services on behalf of the state. Because recently the WhatsApp group also, you might have seen that you cannot arrest a doctor, you cannot arrest an advocate unless until there is a specific thing will be there. Of course, such an immunity will be given. So concept of the sovereign immunity, the state cannot be sued. Of course, now a state can be sued or cannot be, can sue or can be sued also. It depends upon. But the sovereign functions are concerned, the state cannot be sued. So India has adopted the restricted concept of sovereign immunity. Pursuant to the Code of the Civil Procedure of India, foreign states have their organs and instrumentality can be sued with the prior written consent of the Indian government. However, such a consent may not be required where the matter is governed by the special law, that is the Carriage by Air Act 1972, Consumer Protection Of course, the new act has come now, it is 2019, where the legal proceedings are not the nature of the suit, where such an industrial dispute under the Industrial Dispute Act 1947, they need not to take the consent of the government. For instance, you take the one of the case, the Ethiopian Airlines versus Ganesh Narayan Sabu. There is the Ethiopian airline that belongs to the Ethiopia country. The Supreme Court of India reiterated the consistent view in India that the doctrine of sovereign immunity in India was not absolute. So the sovereign immunity is there, it's not absolute because the commercial transaction should be there. At that instance, Ethiopian Airlines can be sued. They need not to take that country consent. And that the foreign states don't have the immunity from judicial proceedings. For instance, the foreign states, it doesn't have because it is the commercial business over there in India, and hence it doesn't get the sovereign immunity. So the commercial transaction and trading activities where the contractual obligations are there undertaken them in India, at that instance, immunity will not be there for the commercial transactions. That's why the Ethiopian Airlines can be sued in India. So legal basis is that. What is the legal basis of the doctrine of sovereign immunity in your state? Of course, the legal basis is Section 86 of the Code of Civil Procedure. Then 1998, the CPC, which provided that no suit may be instituted against the foreign states in India except with the prior written consent of their government. Even diplomatic relations, that is the Vienna Act, Convention 1972, which incorporates certain specified immunities available to the diplomatic missions and their members in India pursuant to the Vienna Conventions on Diplomatic Relations 1961. So, a few articles of the conventions, including the Article 29, 30, 31, 32, 37, 38, 39, have been given the force of law in India by extending the scope of sovereign immunity to diplomatic agents, their families, and members of staff and servants. So, if you want to sue the diplomat, you have to take the permission from their respective country permission before you want to sue it. So, another case is there, Mirza Ali Akbar Kasani versus United Arab Republic, and another a 5 judges bench of the Supreme Court held that the Section 86, Clause 1 of the CPC modifies the international doctrine of sovereign immunity to a certain extent. When a suit is instituted against a foreign state with the consent of the government, it is not open for the foreign state to rely upon the doctrine of sovereign immunity under the international law. So some of the total immunity will not be given over there because it's the commercial and trade functions will be undertaken in India. At that instance, they need not to take the consent of their respective government. The court in later years, by liberal interpretation, limited the immunity of state by holding more or more function of the state as a non-sovereign. So, of course, for the sovereign functions, one cannot sue it. For non-sovereign function, we can sue it. It depends upon which act is sovereign, which is act is not sovereign. It decided in their case laws. So, for instance, you take the Article 32 and Article 26 of the Constitution. In the case of Rudul Shah versus State of Bihar, it is one of the case law where damage is awarded in the writ petition itself because the person who was supposed to be released, still he kept it in the jail. But later on, it came to know that it was released very long back, but his long youth was suffered over there, and he filed a case against the state, and the state would be held liable to pay the compensation. In the laughter that I did this Beep Singh versus State of Jammu and Kashmir, where the same the Rudul Shah was further extended and unlawful detention is there for the MLA not attending the assembly sessions at that instance without a reasonable cause by the police high-handedness. Then the Article 32 is tapped over there. Then the state has to pay the 50,000 by way of compensation for wrongful arrest of the detention of a Beam Singh. So the latest case like the state of AP versus Challa Ramakrishna Reddy on the point clearly indicate that the distinction between the sovereign and non-sovereign powers have no relevance in the present time. The apex court held that the doctrine of sovereign immunity is no longer valid in state activities also, except in a few occasional cases. But here the one of the maxims says that the king could do no wrong. King could do no wrong. There is a rex non-potest peccare. I repeat, rex non-potest peccare. The diversion of the funds required for the other government purposes could bankrupt the state and its growth. What I want to say is the king can do no wrong. That is the concept to be the common law principle. But now the kings are not there and the queens are not there. Even only the state democracy is there, state is there, and at that extent, the state for a particular reasons they could not be sued, but for other reasons that state can sue and can be sued. So diplomatic immunity generally given, parliamentary privileges also given over there, and for the speaker also the privilege is given over there, and that's Article 361 of the Constitution of India, 1949 spells the protection of the president and the governors and Raj Pramukh. That is section 361 2. No criminal proceeding whatsoever shall be instituted or continued against the president or the governor of the state in any court during the term of office. So long that he holds the office, no prosecution would be there for the president as well as the Raj Pramukh, that is the governor. So certain immunity will be given for that, and hence the king and the queen of the state could not be treated like an ordinary person and they could not be sued. Certain immunity will be given to them. So the Supreme Court in the Veeraswamy versus United of India 1991 Supreme Court case 655 has held that the prosecution of a sitting judge can only be done after obtaining the sanction from the President of India, who in turn shall consult the CJI, and the opinion of the CJI would be binding on the President. So whenever you want to the sitting judge, you want to file a suit against him, you have to obtain the consent of the president. When the president will come to take the consent, then he has to consult the CJ and the CJE, and even to the collegium also in certain respects, so that the sitting judge can be sued or at that instance only. Otherwise, the immunity will be given to the judge. So that is about the first one. The statute don't operate retrospectively. So the second one is whenever the statutes are made over there, it will not be implemented for the retrospective effect. It is only the prospective effect. Article 20, sub-article 1 of the Constitution of India provides protection against the retrospective operation law, commonly known as ex post facto law, which will change the legal consequence of action committed before the enactment of the law. The question which is faced during the applicability of the retrospective is whether the statute or the law should be given the retrospective effect, which takes away or impairs the existing law or imposes a new liability. So in my last classes also that I told you that generally the criminal statutes are concerned, it should not be retrospective effect. Yes. So that is the thing which I want to share with you. I am sure that you are hearing me. So if you are hearing me, just you unmute and say, sir, yes, we are hearing you, sir, you proceed. Yes?
Yes, sir, we are hearing, sir.
Very good, very good. So the law does not become a retrospective unless it is clearly mentioned in the law, in the statute itself, because generally it is a prospective effect. And what the Article 20 sub Article 1 also says over there, if any law would be made, it should be a prospective effect but not a retrospective effect unless it is specifically mentioned over there. So that was the thing we observe in the statute. Then the case, Article 20 of the Indian Constitution is divided into two parts. Under the first part, no person shall be convicted of any offence except for the violation of the law in force at the time of the commission of the act charged as an offence. So whenever that offence is committed, at the time the law should be implemented. The law should be in existence. Under that law, whatever the law would be in existence at the time of the offence committed, that law would be only promulgated but not the other laws. A person is to be convicted for the violating the law in force when the act charged is committed. That is what I said clearly. A law enacted later making an act done earlier an offence will not make any person liable for convicted for the violating the law in force when the act charged is committed. So whenever the new law is made it over there, but the new law will not be applied to that law, the acts which committed earlier. So the earlier, whatever the law would be there, or the idea law, that would be applicable, but not the repealing act would be applicable on them. The apex court in the Vijay versus State of Maharashtra held that the penal statute which creates new offences are always prospective, but penal statutes have a great new disabilities, though ordinarily prospective are interpreted to be the retrospective in nature, where there is a clear intendment that they are to be applied to the past events. Unless until there is a clearly mentioned over there in the statute itself, then only it will be retrospective. Otherwise, all enactments are prospective. So these are some of the case law also which I cited, like Prahalad Krishna versus State of Bombay and Srimati Dayavati versus Inderjit. These are the case law which give the sense that how a statute can be retrospective, how a statute can be prospective. So let us observe the according to Lord Denning, the rule that an act of parliament is not to be given to retrospective effect applies only to the statute which affect the vested right. So it does not apply to the statute which only alter the form of a procedure or the admissibility of the evidence or the effect of which the court gives to evidence. So in that right of the given statement and the principles laid down therein, the new act or a rule affecting the existing right or creating a new obligations is presumed to be prospective only. So whenever the law would be made or a new amendment is made, a new section is added and the old section is deleted or omission would be done over there. But this application is only from the prospective effect only, but not retrospective effect. That is the thing. Even the Ratanlal versus State of Punjab also I have given it when it can be applicable and when it cannot be applicable. But in case of a child, the beneficial legislation could be used over there. Then the child will be given the lesser punishment because the today child is tomorrow's national backbone. So that is the view taken in the Ratanlal versus State of Punjab. Even though the act, when it did it, there is no such a law or punishment would be there, but later the repealing act is having a punishment. The punishment is reduced over there where the age is increased. At that instance, the child can take the advantage of the new act that is a beneficial legislation. So now let us go to the next. Another, the existing rights are not to be inferred with. What is the existing right? So your fundamental right cannot be stopped over there unless until there is a reasonable restrictions are imposed on the fundamental rights. So everyone shall have the right to freedom of expression. His right shall include the freedom to seek and receive and impart information, ideas of all kinds, regardless of the frontiers, either orally or in writing or in print. So what I want to say is existing rights are not to be interfered with. So whatever the rights would be there, that will be continued, but it cannot be changed. So that is the thing, the factor which I have given here is doctrine of severability, as known as the doctrine of separability. Suppose the whole law is not severe, not bad, only part of it bad. So what is the part of the bad can be severed and the rest of the part which can be the promulgated. That is what is said in that doctrine. So next is, of course, we can say the section 6 of the TGC also says the same thing. A repealing act doesn't have effect on the repealed act under the 6 circumstances. That's why he wrote, shall not affect. Where there is an act which is not in existence at the time of the repealing, and there is no question of repealing that act. Suppose the act itself is not there at the time when the act was done. At that instance, that cannot be applied. That is the same thing. Or the repealed act will be continued. Any management before the repeal will not be changed. Suppose the management is there, then the repealed one cannot be changed. Effect of any claim or right or privilege or obligations or liabilities acquired or claimed or occurred or incurred or any circumstances so repealed. And at that instance also, the repealed act will be continued and the repealing act shall not have any effect on it. So, E also inquiry or progress, litigations or remedy, then the new act will not be applied, the old act will be continued as it is. It means that all 5 points, there is no effect of repealed act. Repealing act, in other words, the repealed act unaffected the above 5 points. So, a new act which is repeal the old act, but when the 5 conditions are there under section 6 TGCA, it will not be affected, it will be continued. Now let us see the another presumption that the mens rea are required for the criminal liability. Yes, whenever that criminal act will be done, as you read or studied, the criminal intention is a highly important factor. So, like Rakesh and Sarita have been married for 20 years. Recently, Rakesh has begun to suspect that Sarita is having an affair with the Santosh. So, enraged that his wife might be cheating on him, Rakesh buys a gun and shoots Sarita to death. In this case, Rakesh's criminal act was shooting the gun at Sarita, and his mens rea, his intent was to kill her. Yes. So the motive was because of her angriness, and she might have been having an affair. At that instance, yes, he is having the criminal intent to kill the paramour, or not here the paramour, the wife itself, he killed it. So that was the thing where the intention will be taken into consideration at that instance. For example, when a person is attacked by another person with an intention to cause a grievous hurt or injury to, then it is a crime. But when the person who was attacked causes injury to the other person in a private defense, suppose in a private defense he wants to cause injury to the other person, then it is an unintentional act. In the first scenario, guilty mind was present, but the second scenario, no intention causing harm was there. For the second act is categorized as a self-defense and is dealt under section 96 to 106 of the Indian Penal Code. In the first act, to the person is guilty or of criminal act, up to that extent it can be covered. Who will be guilty and who is not guilty. So here, Ranjit D. Odeshi, this case law we already studied the state of Maharashtra, where Lady Chatterjee's lover, the book is banned by the government of India, but still the vendor is selling the book. At that instance, he will be held liable. The reason is, it is absolute ban would be there at that instance. The absolute, they have to follow it. The shopkeeper should not say that I did not know the content of the book. I did not see even the pornography also. I did not know the language in the book was written over there. So he cannot take such a plea. And here intention is taken, guilty mind is there. And hence, whether he read the papers, whether he saw the pornography or not in the Lady Chatterjee's lover's book, but he would be held liable if he is selling by keeping it in the showroom or by keeping in his shop. So mens rea is there. So that will be counted. So it is a mens rea is required for criminal liability. Yes, it is a required liability. But the thing comes, and we have seen also Sweetie versus Parsley, where that lady has given the room rent, but often she comes to the place where to collect only the the letters, the post box, the letters and other things, but she did not know that what is going on over by the students, those who took those who are tenants over there, but actually they are smoking cannabis. So the lady was arrested, but common law principle, they said that yes, she did not have any guilty mind over there, hence she should not be arrested. So it will not be attracted. Section 5 or subsection 6 of the Dangerous Drug Act 1965 will not be applied over there. Hence, the statute did not state any requirement of the mens rea of the offense. Hence, he would be released. So that was the regarding the lady is concerned, because at the time she did not have any mens rea. If a statute deprives a person of his property, or say by a nationalization, or he is to be compensated for its value. Suppose in the road widening, your property is taken by the government. At that instant, the suitable compensation should be given over there. For instance, the 14 banks which are nationalized over there, naturally, a little compensation also be paid to the owner, those who established such a banks. So this is the thing. The Constitution Amendment, 44th Amendment Act of 1978, robbed the right to property, that is the fundamental right, character, and adorn it with the status of the Constitution, the legal right. Now it is not a legal right, it is only left as a paper study for the 91F, and 31 were deleted from the part 3. So it is no more a fundamental right, we can make it out. So that is the thing which I want to share you. And the effect of this amendment was a vast magnitude, that the right to property is no more a fundamental right, but only a constitutional or legal right. So let us see the next is a statute is not intended to deprive a person of his liberty. Suppose if a statute is made over there, but it cannot take away the liberty of a person, and it cannot take away the liberty of the civil rights of a person also. So Article 21 clearly mentioned that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. So no authority in India, legislative or executive or judicial, can deprive a person of his life or personal liberty unless it is justified action under a procedural established by law. So a procedure should be established over there by law when they want to take away the property of somebody else. Of course, if it is taken out, then a market value should be given to them. But if they did not give it, then you can ask for the hike after receiving the money, not before receiving the money. They can go for the hike and file a case in the upper court. So in the Bhim Singh versus State of Jammu and Kashmir, that we already did the high-handedness done by the police, but falsely fabricated way that falsely detained it. Hence, the Bhim Singh filed a case and he got the compensation also, like the 50,000 compensation. Yes, whether the detention was illegal or qualified as a false imprisonment, the Supreme Court, the first respondent in the state of Jammu and Kashmir to pay the Sri Bhim Singh a sum of rupees 50,000 within 2 months from the date of the judgment, because the police used high-handedness force and detained the Bhim Singh illegally without following the procedure laid down by the law and committed the offense of the false imprisonment. So we do have other cases also, right? We can use the above case law. Also, we can use it here to say whether it is applicable or not. So then right against the handcuffing, yes, one should not have the right to handcuff unless he doesn't want to come with you at the time that you have to handcuff it. Otherwise, it is unwarranted and it is against the violation of the Article 21 also. Let us see the Prem Shankar versus Delhi administration. The Supreme Court struck down the rules that provided that every under trial who was accused of non-bailable offense punishable with more than 3 years in prison term would be routinely handcuffed. So even soft criminals will not be handcuffed unless until they are the routine criminals, or they are the trademark criminals. Whether I can use the word. Yeah. So the court ruled that the handcuffing should be restored to only when there was a clear and present danger of the escape of the accused under the trial, breaking out of the police control. At the time only the handcuffing would be there. If anybody handcuffed it, you can bring an action against him when you want to come with him, but still he wants to handcuff you. So next comes a statute generally has effect only in the country where it is enacted. Suppose if the Indian Penal Code is there where it is enacted in India, it could be applicable only in India, but it could not be applied in the Bangladesh or in the Sikkim or Bhutan or any other place. So that is the same thing which is I give in the clear. The acts of the government shall be applicable only the geographical territorial area of the state or central. It is clearly mentioned in the enactment only. So let us see the other, have a quick look. Judicial decisions where the presumptions are followed or rebutted. Let us see the presumption, how it can be followed or rebutted. We can see that is the Badshah versus Sawu Umila Badshah, what say, discuss the scope and the limitation of the picture. Sorry, limitation of the phrase of wife. In this case, a lady married the petitioner as per the Hindu rites and customs. After 3 months of the marriage, the lady came to know that the petitioner has already married, which he did not disclose to the lady while marrying it. The lady claimed maintenance of her and her daughter also. The issue was whether the lady who is not a legally wedded wife may claim for the maintenance under the section 125 CRPC 1973 or not. The answer is yes. That wife or even children also entitled to get the compensation even though there is no divorce at all. Okay, if it is given the judicial separation, yes, it can be, both can be maintainable. So the court followed the Dwarika Prasad Satpati versus Vidyayut Parva Dikshit, where it was held that it was the claimant residing under section 120 of the code succeeded in showing that she and the respondent have lived together as a husband and wife. The court can presume that they are legally wedded spouses. Yeah, the union also will be taken into consideration, but only the thing is nobody should have to knock the door of the court. That should have to come out clearly. So suppose somebody you are living together in a one roof, the years together, the 20 or 30 years also for their children, their grandchildren also they could see them. At the time, the presumption is that they got married. Unless it is rebutted. In the case of the Channumiya, yes, it is the case of Channumiya versus Virendra Kumar Singh, Kushawah. The division bench of this court took the view that the matter needs to be considered with the respect to section 125 Code of Criminal Procedure by a larger bench than the three questions are fundamental for determination of the larger bench. Yes, because that is the reason that we use the larger bench. In the larger bench, the sitting judges may not be in a even number. Even number. Yeah, which is divided by 2. It should be always odd numbers. So if the 7, 9, 11, in that way it could be sit over there with the full bench is concerned. Yes, they can make it. The presumption is there. Yes, they can rebut it. Such a presumption stating that a marriage is done with a keeping view, deceiving in nature, because the first wife is allowed at that instance one should not go for the marriage, otherwise it comes under the bigamy. So let us see the another case law, that is the Devendra Kala Ram versus state of Haryana. The bench observed the word deemed in section 304B IPC, however, does not create a legal fiction but creates a presumption that the husband or relative of the husband has caused dowry death in respect of the decision. In 2012, the Supreme Court, Rajesh Bhatnagar versus State of Uttarakhand, maintained that it is by fiction of law that the husband or relatives would be presumed to have committed an offense of dowry death, rendering them liable for the escape unless the presumption is rebutted. Yes. Another case law that we will say that Maneka Gandhi versus the Union of India. In this case, it was held that the law and procedure which is followed should be just, fair and reasonable. So whatever the law that you will follow will be just and fair and reasonable. That's the maxim say the justice should be done, but it also seems to be done in the spirit. And the cases should not be decided arbitrarily because due process should be followed over there and just and fair and reasonable, and arbitration should not be there in such a cases. The rule of natural justice comes into the power where no partiality is done with anybody dying any irregular activity. The rule of adi alteram partem, that is the primary notion of the principle of natural justice. The principle also says that no one should be condemned unheard. Both the parties will get an opportunity of the fair hearing and justice. The maxim also ensures that the fair hearing and justice will be done toward both the parties, and both the parties have a right to speak. No decision be taken by court without hearing from both the parties. Both the parties have an opportunity to protect themselves. So that was the reason there is a natural justice will be there. You will read in the administrative law also the same thing, in the constitutional law also the same thing, even in the tort also that we use it RD alterum partem. So in the case of the Mangal Ram and others versus state of Madhya Pradesh, I repeat, Mangal Ram and another versus state of Madhya Pradesh. In this case, the wife of the accused was living with her parents for many years and has not visited her matrimonial home for a long time. But within 1 month of returning to her matrimonial home, she committed suicide. Therefore, the court presumed that the circumstance that the accused the responsibility of the death of the lady of the case is a dowry death. But Section 113B Indian Evidence Act, but the husband and her in-laws proved that the death was not caused because of the reasons subject to the cruelty. The court in that matter said that the presumption was rebuttable nature. The rebuttable presumption in nature, the presumption cannot be sustained anymore, hence accused acquitted. So that is the cases where we can come across where the presumption can be rebutted, where the presumption cannot be rebutted. If the presumption is rebutted, naturally he will be held liable. If the presumption is not rebutted at the time, naturally it is a presumption will be taken into consideration. Another explanation we'll see for the purpose of this section, dowry death. For instance, if a person has died, dowry death, especially the female is there, shall have the same meaning as in the section 304B of the Indian Penal Code. So, what is the same corresponding section will be make it on the Dowry Death Act or the Indian Penal Code. The section of the section 304B Indian Penal Code has been added by the Dowry Prohibition Act 1943 of the 1986. The new section is added over there by the amendment. Yeah, this was done in order to solve the increasing problem of the dowry death. The word dowry death has been defined in section 304B Indian Penal Code, and the term dowry has been defined in the section 2 of the Dowry Prohibition Act 1961. So if you see the happen to see the section 112 of the Indian Evidence Act deals with the legitimacy of a child, the section reads as follows. Birth during a marriage are conclusive proof of the legitimacy. The fact that any person who was born during the continuance of the valid marriage or between his mother and any other man or within the 280 days after its resolution, the mother remaining unmarried shall be conclusive proof that he is the legitimate son of that man, unless it cannot be shown that the parties to the marriage has no access to each other than any other time when he could have been begotten. So presumptions are there, we can use it. And section 113 of the Indian Evidence Act also presumption as to the abatement of the suicide by a married woman. When your question is whether the commission of the suicide by a woman who had been abetted by her husband or any other relative of her husband, it is shown that she had committed suicide within a period of 7 years from the date of her marriage, and her husband or such a relative of her husband had subject to the cruelty, the court may presume, having a regard to all the other circumstances of the case, that such a suicide had been abetted by her husband and by such relatives of her husband. See, because her husband or relatives of her husband are rebutted it, and hence he will not be booked under the Dowry Prohibition Act. Otherwise, definitely he will be booked under the Dowry Prohibition Act. Either taking dowry or giving dowry or instigating or helping or abetting, yes, he will be equally liable to be punished. So this is the thing which I want to make it in the today class. The presumption, generally the presumptions will be asked in the short question. When the short questions asked over there, you need not to write elaborately with the case law also. Just you write the statutes don't affect the monarch, the king, crown and state. Statutes don't operate retrospectively and existing rights are not to be interfered with. Then the next one, fifth one is, yes, 1, 2, 3, 4. Fifth one is statutes don't change the common law, and mens rea is also a criminal liability is important. If a statute deprives a person of his property or by legislation or by the government, then he should be compensated. Then the next presumption is that a statute is not intended to deprive a person of his liberty. Suppose a person life and liberty is not taken away there, then yeah, the due process should be followed over there. A statute intended to deprive the person of liberty. Yes, personal liberty cannot be made it over there because due process should be followed whenever the person wants to take the liberty of a person. So a statute generally has effect only in the country where it is enacted. For instance, the Indian Penal Code is enacted. At that instance, this Indian Penal Code will be applicable only in the free India. Yes, sir. Then the judicial decisions where the presumptions are followed or rebutted. Just now that we said the presumptions are rebutted, presumptions are followed. But if a person wants to rebut it, the burden lies on him to further rebuttal. So that is the today's presumptions case laws. We dealt with the cases, and if anything that to be asked, we can ask it. But I already told you that my classes will be continued up to 9th because the 9th is your examination. Is it?
Yes, sir.
Yes, and today is 8th, means tomorrow is the last class, and I will see which will be the best one to cover. At least expect that the people will get the benefit of it. Thank you very much for your patient listening, and we'll see you tomorrow at the same timings, 11:30. And by that, I would like to stop my end the meeting. Yes, thank you very much.